Good morning, good afternoon, everybody. I'm Jeff Ernst with Orange Tree Employment Screening. Our webinar will begin here in just a couple of minutes, and we'll look forward to getting into today's topic on it. Welcome to today.
Thank you, Jeff. So many of you know me. You've spent time with me on these sessions before, but just to give you a little introduction, Heidi Seaton. I'm the Vice President of Legal and Compliance here at Orange Tree. I've been working for background screening or working in the background screening industry for, I think, 21 years now. So been around a while. And when the team asked me to talk today about FCRA compliance, gut reaction is, oh, again, but of course, again, right? Like this is a statute that is ongoing, it's continuing. And because of case law, because of regulatory activity, it reinvents itself over and over again. And so it is something that employers should be spending time thinking about. And so it's a good reminder, it's a good time potentially here as we're ramping back up, coming out of COVID, to be thinking about these issues. My usual disclaimer here, I'm not your legal counsel. I'm not Orange Tree's legal counsel. This is not legal advice. This is intended to be informational or educational in nature. And I really do want to encourage you, if you have a particular question, we probably will have time for some Q&A at the end, but just know my responses will be general, right? Like if you have a particular question about your policy or procedure, I'm going to want to ask you to work with your own counsel on those questions. So all of that said, what should we be thinking about as it relates to the Fair Credit Reporting Act? So this is sort of an overview of what we're going to hopefully get through here in an hour. I can talk about this for much longer than an hour. So obviously, some of these topics are things that we need to cover in brief or in summary. I'll try to go into detail where I can, or where I just think it's really important for employers to be thinking about these issues. But we really just want to spend some time thinking about the Fair Credit Reporting Act. We really can't really talk about the authorization requirement that's outlined as a employer responsibility in the Fair Credit Reporting Act, adverse action as well, and then the certifications that employers are required to make to their consumer reporting agency when they are going to be using consumer reports under the Fair Credit Reporting Act.
Hey, Heidi, I don't know, you may have froze for just about 30 seconds or so. So if there's more than a summary comment in your last 30 to 45 seconds, if you could repeat it for me.
Oh, sure. So again, this is just an overview of what we're going to cover today. Fair Credit Reporting Act, why does it even apply to employers? How does it apply when? We can't really talk about the Fair Credit Reporting Act without also getting into EEOC guidance around criminal history information for employers. And then we'll talk about sort of the big three employer responsibilities under the Fair Credit Reporting Act. We've got disclosure and authorization, adverse action, and some of the certifications that are required under the law. Can you hear me okay now, Jeff?
Yes, you froze again a little bit, but the last 10 seconds have been good.
Okay, all right. So FCRA compliance. So the Fair Credit Reporting Act, I call it FCRA. Sometimes you'll hear FCRA. This is 15 federal law, USC 15, USC 1681. It's been around a long time. It's actually enacted in 1970. It was intended to promote the accuracy, fairness, and privacy of consumer information in the files of consumer reporting agencies. That's a CRA. It protects consumers from both willful and negligent inclusion of inaccurate information in their consumer reports. And it regulates the collection, dissemination, and use of consumer information, including consumer credit information, including consumer reports that are prepared for an employer. why does a law called the Fair Credit Reporting Act apply to an employer? Because it's, well, number one, unfortunately named, right? It should be the Fair Consumer Reporting Act, but at the time when it was enacted, mostly it was just credit bureaus. So it does apply to a consumer report, and a consumer report is defined as any communication or information by a consumer reporting agency that bears on a consumer's credit worthiness, credit standing, credit capacity, so very squarely in the credit space, but also character, general reputation, personal characteristics, or mode of living, which is then used for a purpose as serving as a factor in establishing consumers' eligibility for employment, right? So that's how the Fair Credit Reporting Act comes into something that employers need to be concerning themselves with. Note in that definition, the FCRA applies when there is a consumer reporting agency. So you, employer, if you are perhaps contacting other employers directly to verify employment, or contacting schools directly to verify attendance, in that case, and except in probably California, the Fair Credit Reporting Act doesn't apply. It applies when there is a third party, right? When there's that consumer reporting agency that's preparing the report on your behalf. This is why, by the way, every once in a while we'll get a prospective client or a new client that will come in and be unaware that the Fair Credit Report even applies in the circumstances where they're getting a background check. It's likely because that employer was maybe either not doing background screening before, or they were doing it themselves, right? So when you bring in a third party, that consumer reporting agency like Orange Tree, there's the Fair Credit Reporting Act obligations that come along with that. And by the way, the consumer report that is covered by the Fair Credit Report is broad, right? So as I mentioned, it's not just if you're ordering credit from us. It includes information, any information bearing on characteristics, reputation, mode of living. So certainly employment history, education history, references, criminal history information, all of those sorts of things would bring the FCRA into play. And what are those concerns or considerations about the Fair Credit Reporting Act? So the Fair Credit Reporting Act allows for statutory damages for violations of the act. So willful violations allow for, between $100 and $1,000 per error or per damage, right, or per consumer, in addition to punitive damages, court costs, attorney fees. All you need to do to get, if you're plaintiff counsel, to get punitive damage, court costs, and attorney's fees is show that the employer's misuse or failure to meet their obligations under FCRA was willful. And because FCRA lawsuits against employers often involve errors with an employer's standard background process, those processes tend to be committed consistently over and over again because you all are very well-trained HR professionals. You do the same thing over and over again. Unfortunately, those practices, if they're not done right, become a target for class action litigation under the Fair Credit Reporting Act. And class action is way up. I was looking at some statistics this week as I was preparing. In 2010, there were 1,430 FCRA suits brought during that year. In 2020, even with COVID, 4,350. Obviously, not all employment related, right? FCRA is broad. It covers a number of topics and permissible purposes. But that's a significant increase in FCRA suits over time. So we do keep an eye on it. And employers should be thinking about their FCRA compliance. Our second topic here, you might be wondering, hey, I signed up for a webinar about Fair Credit Reporting Act. Why are you talking to me about EEOC compliance? And the reason is they go hand in hand a little bit, right? If you're an employer that's especially using a consumer reporting agency to collect information about your candidate's criminal history, the EEOC has an opinion about that use of that information. And so the Equal Employment Opportunity Commission is responsible for oversight and enforcement of the Civil Rights Act of 1964. So another law that's been around a long time, has been concerned with criminal history information for many years. And then in 2012, there was some enforcement guidance that they published. It was directly for employers. It was on the topic of employers' consideration of arrest and conviction records in their employment decisions. And the reason is because they believe in some instances, use of criminal history information can be discriminatory under Title VII. And so they provided this guidance, and I could do a whole hour just on the guidance, right? So I'll try to be somewhat brief here. But really what they did was, in the guidance, they sort of returned to some earlier guidance that they had provided. They said, employers, if you're going to consider criminal history information, you have to develop a targeted screen, considering at least the nature of the crime, the time that's elapsed since the crime, and the nature of the job. So these were the three factors that came out of Green versus Missouri, the Missouri Pacific Railroad, 1977 case law, right? So it's been around a long time. And then the guidance goes on to say employers then, as part of their policy, need to provide an opportunity for a consumer or a candidate that's potentially going to be excluded from consideration to be hired, the opportunity for an individualized assessment to determine if the policy as applied is job related and consistent with some business necessity. It didn't require an assessment in every single instance or circumstance, but they did say a failure to use or to do an individualized assessment is more likely to violate Title VII. So, and then they went on to describe the factors or what goes into doing an individualized assessment. It said employers should be informing individuals that they could be excluded based on past criminal history. And then providing them an opportunity to demonstrate why that exclusion isn't proper as it's applied to them. And so they said employees should be given the opportunity to provide feedback or provide information about the public or the criminal history record, perhaps feedback where they would indicate they weren't correctly identified in the criminal report, or that the record is otherwise inaccurate, or provide some other relevant information. They encourage employers to consider the facts or circumstances surrounding the events or the offense or the conduct, the number of offenses for which the individual was convicted, how old the individual was at the time of the conviction or at the time of release from parole, evidence that the individual had performed the same type of work after the conviction with the same or a different employer where there was no known incidents of criminal conduct, the length and consistency of criminal history before or after the offense or the conduct, any rehabilitation efforts, any education or training that the individual had received, employment or character references, or other information regarding fitness for the particular position, and then whether or not the individual had been bonded under some either federal, state, or local program, just because the bonding process implies a level of trust, right? So that's been around a while now. This guidance was from 2012. And so out of that, then the EEOC created or summarized a list of best practices for employers. And they said, in general, employers should eliminate policies or practices that exclude people from employment based solely on a particular criminal record, right? They should do that targeted screen, train their managers and hiring officials and decision makers about Title VII and potentials for discrimination, develop a narrowly tailored written policy and procedure for screening. Oh my gosh, sorry, a bird just flew in the window. He flew away. Identify essential job requirements and the actual circumstances under which the job is performed. Determine the specific offenses that would demonstrate unfitness for a particular job, so for each job. Determine the duration of exclusion of criminal conduct based on all the available evidence. So determine, even if you identify that a particular criminal offense is job related, is there some point in time after which it becomes less job related, or after which exclusion from that position would become less of a business necessity or perhaps lower risk. To consider and do the individualized assessment, and then record justifications for your policies and procedures, and then note and keep records of any consultations or research that you did to come up with your policy. So significant ask here from the EEOC around employers' consideration of criminal history information. And then they also encouraged employers to think about the timing of when and under what circumstances they would be asking consumers or their candidates about their criminal history. So wait until later in the hiring process. And that goes to another topic we'll talk about here, which is ban the box or fair chance ordinances. And then to keep information about the consumer, the background screening report and process confidential. So EEOC compliance sort of running hand in hand with your FCRA obligations. It's been a while since this guidance. What have we seen since then? Well, we've seen some enforcement action against employers. We certainly have seen courts reference the guidance, right? So when a court references the guidance and uses it to help them make decisions, that becomes part of case law. And so in some cases, we've seen some case law develop around it. And then perhaps more significantly, in my opinion, just my opinion, states and localities have begun, when they're passing ban the box ordinances or fair chance laws, have begun to incorporate those requirements about targeted screen, doing individualized assessments, documenting decisions into their ban the box and fair chance laws. So that means it's no longer just guidance from the EEOC, it actually becomes a statutory or regulatory requirement at that locality, applicable to some employers depending upon where they are and where they're doing business. So that's why we continue to talk about the EEOC guidance, especially as it relates to Fair Credit Reporting Act, because yes, we have the Fair Credit Reporting Act. We also have state laws that can require additional steps from employers as it relates to their use of consumer reports. So then kind of heading back over into FCRA, the big three that I think employers should be thinking about when it comes to Fair Credit Reporting Act compliance are disclosure and authorization requirements, adverse action, and their certification requirements. So disclosure and authorizations are the first topic we'll cover today. And honestly, we should stop talking about disclosure and authorization as though it's the same thing. It is not. The Fair Credit Reporting Act requires disclosure, which is the employer disclosing to the applicant or their employee that they intend to do a background check. And there's authorization, and that is the employer getting the candidate's authorization to do the background check. You can see they're subtly different. For years and years, because the FCRA nominally allows it, the disclosure and authorization was done as a single step, right? It was one page, you had your disclosure language on the top, you had your authorization language on the bottom, you had them acknowledge, had your applicant acknowledge that with a signature on the bottom. It's become problematic over time, and we're going to spend a little time on this slide just talking about some case law, because it's the thing we hear about the most. The problem is the FCRA requires that the disclosure regarding a consumer report be a standalone disclosure and that it be clear and conspicuous. We'll talk a little bit more about that as we get into case law. There's a second type of disclosure. This gets almost no press, but there's a little bit of case law about it. But there's a second type of consumer report called an investigative consumer report, and that has its own disclosure. So when a consumer report is based on personal interviews concerning an applicant's character, general reputation, personal characteristics, and mode of living. So again, a consumer report, but when it's based on personal interviews is when the investigative consumer report disclosure requirement comes into play. The consumer is, or the employer has additional obligations. So they have to give notice that you may request an investigative consumer report, and they have to be given a statement that they have a right to request additional disclosures, as well as a summary of the scope and substance of that investigative consumer report. When does it become a consumer report? Certainly, we think it becomes an investigative consumer report when we're actually doing a reference, right? When we're actually doing an interview, we're calling someone, we're sending them an online form, we're saying it's personal to that person, we're asking for their opinion, sometimes subjective information. Do you think this person did a good job? Those sorts of personal interview services are very likely to be an investigative consumer report. And then for a belt and suspenders approach, right, like why not? Employment verifications, sometimes depending upon how they're collected, potentially could fall within the realm of being an investigative consumer report. So you might as well make the investigative consumer report disclosure in those cases as well. So those are the two disclosures. And then, as I mentioned separately, authorization. So authorization is getting the consumer's authorization or consent to obtain the consumer report. That's the statutory requirement. That's the FCRA requirement. The other important part about authorization is it's also your opportunity to explicitly get the consumer to consent to third parties or information sources to provide information to you, the employer, to Orange Tree as the consumer reporting agency, in order to prepare that consumer report, right? So generally your authorization is going to have language about, that the applicant authorizes you, the employer, to procure a consumer report, and then also authorizes information sources, DMV or driver services, employers, schools, state agencies to release that information to you or the consumer reporting agency. So the authorization by statute, you have to collect it. And then there's also this sort of more practical use of the authorization form. And that is, you give it to the background screening company. So the background screening company, the CRA, can give it to those sources so that when we call them and say, hey, can you verify this employment, or can you provide information about this public record, when they ask for an authorization or a consent form, we have a document to give to them. You can also use your authorization to notify or get the consumer or the applicant's authorization to do ongoing screening. So if you are an employer that's considering monitoring for background screening, if you are an employer that by policy you do an updated screen or a new background screen when you're promoting someone, or if you are bringing someone back from furlough, perhaps, you might want to include where it's allowed some what's called evergreen language, which is about continuing just authorization, right? So language maybe like, you know, I authorize employer company to do background check, and I also authorize as part of the pre-employment screening process, and I also authorize ongoing screening for the duration of my employment with X company, right? Some states do limit that, by the way, so California, be especially careful there. You've got to make disclosure every time you're doing a background check in California, Massachusetts potentially as well. I say all of this about things you can include in your authorization form. You want to make sure you're only doing that if you are keeping your authorization form separate from your disclosure, right? Nominally, not even nominally. In fact, the Fair Credit Reporting Act allows an employer to combine the disclosure with the authorization. But if you start to include things in the authorization that are something other than the disclosure, then you get in trouble as it relates to your requirement for your disclosure to be standalone. So best practice is at this point, do a separate disclosure, do a disclosure regarding the consumer report, do a separate disclosure regarding an investigative consumer report, do a separate authorization form, so that you can potentially then use your authorization form to do other things, right? We're going to talk about why it's problematic when employers use a combined disclosure and authorization form. And I think the best way to do that is to just talk through a little bit of case law on the topic. So I'm going right to the Ninth Circuit, which I know it doesn't apply to everyone, right? The Ninth Circuit is broad. It's California, Hawaii, Alaska, Arizona, Idaho, Montana, Nevada, Oregon, Washington, Guam, North Mariana Islands. So it does cover a lot of ground. And I do understand, though, that the Ninth Circuit does not apply potentially to all employers. But why should we care about the Ninth Circuit? Employers with even a limited presence in one of those states could find themselves drawn into a class action litigation in that circuit. And the other thing to know is that federal judges in other locations can and do find the Ninth Circuit views on FCRA compliance persuasive. And we do see them pulling in opinions from the Ninth Circuit into other federal courts, into district court opinions, and into circuit opinions as well. So the reason that they're popular is the Fair Credit Reporting Act is a consumer protection law, right? So it goes back to the very first slide. Why do we care about the FCRA? We're an employer. It is a consumer protection law. And so it's attractive sometimes to courts, to judges when they are trying to come up with an opinion. So some of the interesting case law coming out of the Ninth Circuit. We had Syed from 2017. In that case, an employer had included liability and release language in its combined disclosure and authorization. And there the court held that including liability or release waiver language in the FCRA disclosure violated the requirement that the notice consists solely of the disclosure. And so it didn't meet that standalone requirement. In fact, they said that including, in particular, just because it was waiver or limitation of, it attempted basically to limit the consumer's rights under FCRA. They said that that was a willful violation, which, as we know from our early discussion about Fair Credit Reporting Act, brings in enhanced damages. right? So we had that case. We had Gilbert v. California check cashing stores. That was another case where the court analyzed the authorization and disclosure language and said it was confusing. Basically, it didn't meet the clear and conspicuous requirement. And it did basically a grammar test. It had the disclosure had a sort of compound and run-on sentence that they just said was confusing. I could get into the specifics of what was confusing about it, but imagine a grammar test, right, in an employment form document, very often drafted by attorneys, right? So sometimes they're long, sometimes certainly they are compound sentences. And so this got the attention of a lot of employers. We started to see, so this is in 2019, employers started to start taking things out of the disclosure and start to separate the disclosure from the authorization. And then in 2020, we had Luna v. Hansen, another FCRA case that was analyzed by the Ninth Circuit. This one has actually good news for employers because it clarified that the standalone requirement is a physical requirement, not a temporal one. So it said, so in this case, the employer had separated the disclosure and authorization from other forms. So I think I'm trying to remember what the other forms were, maybe like a limitation of liability or an at-will employment statement. They were separate forms, but they were presented to the applicants or consumers sort of one after another, right? Like maybe a stack of forms or maybe one form after another in an electronic user interface. And the argument there was that violated the standalone requirement. And the court said, no, employers don't violate the FCRA by presenting applicants with the FCRA disclosure on a separate piece of paper together with other employment application forms. It said no authority suggests that a disclosure must be distinct in time from the presentation with other forms, as long as the FCRA disclosure is physically separated from other documents and information. So good clarification there for the employer. In this case, the employer had actually separated the disclosure from the authorization. So a best practice there. And they said too, even though the authorization form included other notices, so it had waivers, it had some other notices, since it didn't include the disclosure, it didn't fall foul of that requirement for the disclosure to be standalone or separate or clear and conspicuous. And then last, we've got in 2020 also Walker v. Fred Meyer. So there we learned employers, no good deed goes unpunished. That employer's disclosure form had information that the court characterized as helpful to the employee or applicant, but still found that the information was extraneous, and so ran afoul of the standalone and clear and conspicuous requirements. So in that case, I'm trying to remember what it had. I think it was state law disclosures. So they said, even a disclosure made in good faith by the employer to help the applicant or employee understand their rights constituted extraneous information that rendered the disclosure non-FCRA compliant. The upside here coming out of that opinion was the court did an analysis of that specific form, and it gave us an opinion. It finally gave us employers some guidance about what is extraneous, what's not extraneous in a disclosure form. And they said, basically, what's not extraneous is a plain statement that a consumer report's being obtained, a concise explanation that the report of what a consumer report is, and the permissible purpose for which it will be used. So what type of consumer report will complete it, and who the consumer reporting agency was. They thought that was probably okay. Extraneous, though, was they said information about the consumer's right to inspect the content of their consumer file with the CRA. So even though that really is a consumer right, they thought including that information in the disclosure was extraneous. Including investigative consumer report disclosure language in the general FCRA consumer report disclosure, they said was extraneous. So again, even language that provided true and accurate information about the consumer's rights, this court said, is still extraneous. And they said the employer's intentions didn't matter. No exception for information the employer might believe would be helpful. So if you haven't looked at your disclosure and authorization forms lately, now's the time. Take a look at them and also be thinking about some state law considerations. So some states require the additional disclosure. So California, Maryland, Massachusetts, Minnesota, New Jersey, New York, Oklahoma, Washington. Those are all states where you should be thinking about, hey, have I made this specific state disclosure in addition to the general disclosure? And again, other issues identified in case law here were making the state notice disclosures on the same form as your general FCRA disclosure, probably not allowed. So lots of information on disclosures and authorizations, but I have a few more slides to get to, so I'm going to move on.
Hey Heidi, can we have maybe just a quick question on that chart? There was a question that came in: are there greater risks processing investigative consumer reports, and what are those risks and/or compliance risks with those type of reports?
There's greater obligations, right? So we've covered one here, and that's the requirement to do this investigative consumer report disclosure. Potentially, if you think about the fact that EEOC guidance doesn't apply to the contents of an investigative consumer report, that's actually less risk. You are more likely to I don't think so. And again, that's just my opinion. I think employer consideration of criminal history is much more risky from a legal standpoint, right? From a potential discrimination standpoint, from a are you doing your individualized assessment, and are you following adverse action standpoint? I think investigative consumer report disclosures, especially if you consider only references, I think it's somewhat rare for employers to make a decision about whether or not to hire someone based on a reference, right? It tends to be more the totality of everything in the consumer report. There's usually more than one reference that's contacted. And then if there's some subjective or fact question coming from that reference, very likely you're getting that factual information from an employment verification as opposed to from a reference. But certainly, you know, it is not risk-free, just like any other use of the consumer report. So adverse action. So this is sort of the second big responsibility that I think employers should be thinking about as it relates to consumer reports. If you look at FCRA class action, where employers are involved, it's I would say it's the second most likely thing you're going to see class action activity about, usually related to the contents or what sort of disclosure the employer is giving as part of their adverse action process. So what's required? The Fair Credit Reporting Act for employers, by the way, this is not like other uses under the Fair Credit Reporting Act, but for employers requires a multi-step adverse action process. And the first step has to happen before you actually take an adverse action. So before you withdraw an offer, before you decide not to promote someone, before you do that, the employer is obliged to provide this pre-adverse action notice. And they need to provide a copy of the consumer report. So again, if the employer is going to use the consumer report to make a decision in whole or part based on that consumer report, right? So there could be other factors that you're considering, but if you use the contents of the consumer report for any part of that decision, likely this adverse action process requirement applies. So you need to provide a copy of the consumer report. You need to provide contact information of the consumer reporting agency, the background screening company that completed the report, and instructions on how they can contact the consumer reporting agency. You need to provide a copy of the current Consumer Financial Protection Bureau's summary of your rights under the Fair Credit Reporting Act document. And then there may also be state or local law requirements. So you want to look to those ban the box laws, to those fair chance laws, to see if there's anything else you should be doing prior to taking an adverse action. So it might be something like doing an individualized assessment or allowing someone to opt in to an individualized assessment process. You might use that pre-adverse notice to give a consumer a way to get in contact with you if you want to allow them to do an individualized assessment. And be a little careful too about your summary of rights document. So it may have flown under some radars in 2018. There was a change to that document. So it had been, I think the last version had been around since 11 or 2012, something like that. But there was a change that happened in 2018. I do still sometimes see out on the big bad internet old versions of that fair credit, of that summary of rights document floating around. And so if you're not sure if you're using the right version, take a look at it. The 2018 version, the CFPB's summary of rights version, has inserted a section about a right to a security freeze. So look for that security freeze language in your version to make sure you got the right one. So that's pre-adverse, right? The second step, which sometimes we talk about adverse action for employment as a two-step process, but honestly, think if you can about a three-step process. And then that second step is actually just wait, do nothing. And we understand that that is super hard for employers to do. We get it. Employers are in a race to fill open positions. There's competition for applicants and employees. But the Fair Credit Reporting Act says that employer needs to wait a reasonable amount of time after they've provided that pre-adverse notice to the consumer to allow the applicant to, number one, receive it. Number two, determine whether there's information in the report that's inaccurate or incomplete, or some other reason that they want to challenge the pre-adverse decision, and then to do something about it, right? Consumers have the right to dispute information in their consumer report if they believe the information is inaccurate or incomplete. And background screening companies have an obligation to do a timely reinvestigation and to update that consumer report if after that reinvestigation we determine that their correct information was inaccurate or complete, or if we just can't verify it within a 30-day period. And so think about wait as your second step when you're thinking about an adverse action. Train your hiring managers and your HR staff to think about waiting as well, right? So they're going to want you're going to want to make sure if when you've sent out that pre-adverse action notice, don't send the offer withdrawal letter right away. Wait until the final adverse action notice. You need to give them that meaningful amount of time. What's meaningful? FCRA case law. FCRA doesn't say, and so case law that developed was that it's probably that something less than 5 business days probably is not reasonable. And then think about if you've got local or state statutes or ordinances that you need to comply with. They're, again, probably going to be in that fair chance or ban the bot statute about how long to wait, be especially thinking about California, New York City, those sorts of jurisdictions tend to require a defined waiting period. And then the third step, so you've waited your reasonable amount of time. The third step is to go ahead and proceed with the adverse action. So if they haven't disputed, if there's no reinvestigation going on, if they haven't given you information that mitigates the information in the consumer report, if you've maybe gone through an individualized assessment process during that waiting period, if the decision was based on criminal history, then there's a second communication that needs to go out, and it's adverse action, or sometimes called final adverse action notice. And so in that case, the communication needs to provide confirmation that the decision is now final, contact information for the consumer reporting agency, because again, they can dispute even after the adverse action process has already passed. Statement that the background screening company didn't make the decision and can't provide the reason for it. And then a notice about their right to dispute, and also about their right to get an additional copy of the report. So that's.
Hey Heidi, I mean, this may be a difficult question to answer specifically, but I'm just gonna throw it out there anyhow. The question came in, and that is there a standard SLA time for the dispute process?
I think you'll find a background screening company not terribly willing to SLA the dispute and reinvestigation process. Under the statute, consumer reporting agency has 30 days to do a reinvestigation, and we can extend for up to 15 days if we get material information during that after the dispute's been started. But the fact of the matter is a consumer reporting agency understands that doing the dispute and reinvestigation as quickly as possible, while still making sure it's a reasonable reinvestigation, is best case scenario for everyone, right? We understand during that time, employer, number one, is having to hold open the position. So we understand the pressures there. So that motivates us to move quickly. Consumer, potentially, if there was incorrect information that was provided on the report, that's potentially, a damage, right? So the quicker we can get the report, the dispute and reinvestigation completed, potentially the sooner we can get inaccurate or incomplete information off of their report, the less likely they are to actually have been damaged by that incorrect information. So we get it. Background screening companies get it. Most times, I think, Jeff, your metric at the beginning of the session about how quickly we do criminal background checks, disputes, sometimes they take a little longer, right? Because, for let's say a criminal record, the consumer is disputing the level of the offense. On the public terminal, it says it was felony. Turns out that during the course of adjudicating that case, it got downgraded to a misdemeanor, but the public terminal still says felony. And so we might have to ask the court clerk to look at the actual case file, right? Like, pull the case file, let's see what was actually decided in that court case. Because it could be that the public terminal just never got updated with the level of the offense. Courts, regulators tend to, they think, hey, background screening company, if you can get the background check done in 1, 2, 3, 4, 5 days, it shouldn't take you much longer than that to do the reinvestigation. And certainly if background screening companies won't give you an SLA on disputes, they should be able to at least give you their historical information on how long does it usually take in the aggregate to do your reinvestigations and to get reports updated when they need to be updated.
Thank you.
And then certifications. So this is actually like the easiest slide. Look at me coming in on time. Sometimes employers don't realize if they haven't analyzed the FCRA line by line like I have. Employers ask us, clients ask us, hey, why do we have to make these certifications in the user agreement? And the answer is because the FCRA actually requires it. So employers or end users of consumer reports have to certify to the consumer reporting agency that's going to be preparing their reports that they will make those disclosures that are required by law, that they'll obtain the authorization to do the consumer report, they'll comply with the law, that they will follow adverse action requirements, and then that they will use the information in a way that doesn't discriminate against applicants or employees, or otherwise misuse the information, especially as it really relates to federal and state equal employment law or regulation. And so when you get asked to make those certifications, this is the reason. It's actually laid out in the statute that employers are obliged to do it, and consumer reporting agencies are obliged to collect these certifications from their end user customers. So that's what I have today to cover. Jeff, thanks for